Good afternoon, everybody. Assuming that somebody is watching. And welcome, Peter. Nice to see you again.
Thanks, Trevor. You too.
In real wintry Cape Town weather. Many of my colleagues have gone to sunnier climes, although I suppose that right at the moment there are certain advantages in being in Cape Town compared with some other places. Anyway, let's not talk about that. Right, our topic for this afternoon is substance versus form, which is very often something that is required when one is asked to express an opinion in relation to an arrangement. No value attached to the use of the word arrangement, a contract or a transaction. Will it survive the test of substance over form? Okay, so I'll kick off just with a bit of background, and then Peter will take over, and then, as usual, we'll start chatting to each other. I think the logical place to start is the case of Zandberg versus Van Zyl, which is a 1910 decision of Judge Innes. He was then Innes J.A., which meant he'd not yet become the Chief Justice. And he's, of course, one of our outstanding judges. And he said the following, and this is quoted by Judge Watermeyer in the Randalls Brothers case. So Innes J.A. said the following: now, as a general rule, the parties to a contract express themselves in language calculated without subterfuge or concealment to embody the agreement at which they have arrived. They intend the contract to be exactly what it purports, and the shape which it assumes is what they meant it should have. Not infrequently, however, either to secure some advantage which otherwise the law would not give, or to escape some disability which otherwise the law would impose, the parties to a transaction endeavor to conceal its real character. They call it by a name or give it a shape, intended not to express, but to disguise its true nature. And when the court is asked to decide any rights under such an agreement, it can only do so by giving effect to what the transaction really is, not what in form it purports to be. The maxim then applies: plus valet quod agitur quam quod simulate concipitur, and don't ask me to translate it, it's hard enough to pronounce it. But the words of the rule indicate its limitations. The court must be satisfied that there is a real intention, definitely ascertainable, which differs from the simulated intention. For if the parties in fact mean that a contract shall have effect in accordance with its tenor, the circumstances that the same object might have been attained in another way will not necessarily make the arrangement other than it purports to be. The inquiry, therefore, is in each case one of fact, for the right solution of which no general rule can be laid down. Right, that's what Innes C.J. said in Zandberg versus Van Zyl, and then Judge Watermeyer in Randalls Brothers versus Commissioner for Customs and Excise versus Randalls Brothers in Hudson said the following. And these are two of our really all-time great judges, Innes and Watermeyer. So Watermeyer said, I wish to draw particular attention to the words, quote, a real intention, definitely ascertainable, which differs from the simulated intention, because they indicate clearly what the learned judge meant by a disguised transaction. A transaction is not necessarily a disguised one because it is devised for the purpose of evading the prohibition in the act or avoiding liability for the tax imposed by it. The transaction devised for that purpose, if the parties honestly intended to have effect according to its tenor, is interpreted by the courts according to its tenor. And then the only question is whether, so interpreted, it falls within or without the prohibition or tax. A disguised transaction, in the sense in which the words are used above, is something different. In essence, it is a dishonest transaction. Dishonest inasmuch as the parties do not really intend it to have inter partes, in other words, amongst themselves, the legal effect which its terms convey to the outside world. The purpose of the disguise is to deceive by concealing what the real agreement or transaction between the parties is. The parties wish to hide the fact that their real agreement or transaction falls within the prohibition or is subject to the tax, and so on. Such a transaction is said to be infraudem legis, in fraud of the law, and is interpreted by the courts in accordance with what is found to be the real agreement or transaction between the parties. Of course, before the court can find that a transaction is infraudem legis in the above sense, it must be satisfied that there is some unexpressed agreement or tacit understanding between the parties. If this were not so, it could not find that the ostensible agreement is a pretense. The blurring of this distinction between an honest transaction devised to avoid the provisions of a statute and a transaction falling within the prohibitory or taxing provisions of a statute, but disguised to make it appear as if it does not, gives rise to most of the confusion which sometimes appears to accompany attempts to apply the maxim quoted above. So I think what Watermeyer was adding was that it's not enough just to allege that something is a sham, or not the substance of a transaction, but only the form. In order to say that something is a sham, you've got to say what the real transaction is. So if SARS suggests to the taxpayer that the transaction is a sham or is simulated, it's up to them to then say, well, what is the real transaction? Okay, so much for that. That is kind of introductory. In 2010, a judgment which is probably well known in tax circles was handed down by the Supreme Court of Appeal, and Judge Lewis, who happens to have been in my class at university, so I do know her otherwise than just having appeared in front of her. She gave a judgment in the case of NWK. And in paragraph 55 of her judgment, she said the following: in my view, the test to determine simulation cannot simply be whether there is an intention to give effect to a transaction in accordance with its terms. In other words, what had been said by Innes. Invariably, where the parties structure a transaction to achieve an objective other than the one ostensibly achieved, they will intend to give effect to the transaction on the terms agreed. The test should thus go further and require an examination of the commercial sense of the transaction, of its real substance and purpose. And here's the killer. If the purpose of the transaction is only to achieve an object that allows the evasion of tax or of a peremptory law, then it will be regarded as simulated. And the mere fact that the parties do perform in terms of the contract does not show that it is not simulated. The charade of performance is generally meant to give credence to their simulation. Now that set the cat amongst the pigeons, and a number of people had something to say about that, and I was one of them, but there are other more learned people than me who expressed similar views, and took the court to task for seemingly changing the test. But that's the beginning of the story and not the end of the story, and Peter's now going to take the story a bit further.
Thanks, Trevor. Thanks a lot. And I think the line that I listened to when you gave the quote in NWK is: the test should thus go further and require an examination of the commercial sense of the transaction, of its real substance and purpose. And our concern, your concern, my concern, the concern of a lot of us in the advisory world is that this judgment imported a new test for simulation. So it didn't just look at whether a transaction was disguised. It also looked at whether there was a commercial purpose for the particular transaction. And that was something new. So when you're looking at when we started writing opinions after NWK, You looked at whether a transaction was disguised or dishonest. And then you also had to test whether there was a commercial purpose in relation to that transaction. And that led to all sorts of interesting debates amongst us, Trevor. For example, what is commercial purpose? Purpose is a subjective test, but is commercial purpose, is that somehow import some level of objective analysis into looking at a transaction? Or is there an equivalence between purpose in commercial purpose and purpose in GAR, which looks at the sole or main purpose? So is this, has this imported some part of the GAR provisions into our law relating to simulation or substance over form? And the world became a tricky place for us tax lawyers in terms of advising on simulation for a number of years. And then in March 2014, the Roshcon case came along, and that was a unanimous judgment of the SCA delivered by Judge Shongwe. The facts were very briefly that Roshcon bought a whole lot of trucks and Westbank financed them, and Westbank reserved ownership in relation to those trucks until they'd been paid for. And Roshcon said, hang on, that's a simulated transaction. There's no commercial purpose behind this, and the real transaction is that you, Westbank, have lent me money, and I, Roshcon, have provided security over my trucks. And this reservation of ownership to US Bank is simulated, and the courts need to ignore that. So the argument was who owned the trucks, effectively. And the Supreme Court of Appeal very gently nudged our law back onto an even keel and back into the path of simulation that you quoted, Trevor, in those earlier cases. And it basically said the NWK judgment and the piece that we've quoted and focused on must be read in context. And it wasn't the intention of the court to upset the established principles. And it restated the simulation doctrine as being along the following lines. A simulated transaction is one where there's a deliberate disguise. You're disguising the transaction. It's a dishonest transaction. It's a transaction where you say one thing, but you actually intend something else. They went on to say, to put it in a positive way, and said a test for simulation is a question of genuineness. If a transaction is genuine, the courts will give effect to it. And if it's not, they'll give effect to the transaction that it conceals. And they said that when you're looking at, I always say to my clients, it's the 3 Ds, dishonesty, deception, and disguise are the tests for simulation. And the court said, when you're looking at disguise, you must look at things like, are there unusual features which serve no commercial purpose? Are there non-arm's length terms? Is there something strange or unusual about the arrangement? And the presence of unusual features that serve no commercial purpose give rise to a suspicion that it's not genuine. So the test is whether it's genuine or not. But if there's an unusual feature that has no commercial purpose, then you can say, well, is it genuine? And it raises that question. And then the court went on to say, well, this was the case in NWK. There were a series of self-cancelling features intended to disguise the true nature of the transaction, which was a loan. So they said the requirement of disguise was met in NWK, and therefore NWK was correctly decided. I think it was a little bit of back-solving, to be honest, to get to that position, but it was a very happy day in March 2014 when we read the Roshcon case from the SCA, Trevor, and I think that sort of takes us to the next judgment, which was the Bosch case.
Yeah. Can I just I've got the Wallace's judgment in Roshcon here, and in a footnote he says this is writing at the time. It appears that in some circles he's just quoted what Carol Lewis had said. And particularly the statement, blah, 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 has been understood to condemn as simulated transactions any and all contractual arrangements that enable the parties to avoid tax or the operation of some law seen as adverse to their interests. And then there's a footnote. and he refers to 4 people. The first one is me, an article in the Taxpayer, then Eddie Bromberg, SC, NWK and Founders Hill in the Taxpayer, somebody called CJ Pretorius, and then Andrew Hutchinson and Dale Hutchinson in the South African Law Journal. And I just use this opportunity to say I'm very happy to keep company with Eddie Bromberg and Dale Hutchinson.
And quoted in the Taxpayer, of course. Where else?
Of course, yeah. Just while reading what Watermeyer had said, I just noticed to myself the word pretense. You know, what Wallace held in Roscon is that, in a nutshell, the contract must be genuine. Test for simulation is whether or not it's genuine. And another way of looking at it is it a pretense? If the answer is yes, then it is. And, you know, this is not trying to be personal in relation to the judge who wrote the judgment in NWK, but really the court could have come to the conclusion that it did without that paragraph 55 of the judgment. It wasn't necessary to take the test any further. The taxpayer failed the test on the old test.
I think that's the point. It was a disguised transaction. There were, as I said, self-cancelling features that were there to disguise its true nature, which was a loan. So they didn't need to go further and sort of look at commercial purpose. Yeah.
Then hot on the heels of Roscon comes the decision of Bosch. So can I just say this as well? My feeling was always that, I can't quite remember how you put it, Peter, but I think the Wallace in Roscon was gently putting. He was saying that everyone has misunderstood what the judge said. I don't think we misunderstood what the judge said. I think he's gently correcting what she said, but without saying so, being very ultra diplomatic. Anyway, hot on the heels of that came the Bosch case. And in the Bosch case, Judge Wallace, again, same judge, said in paragraph 40, he said that submission involved a misunderstanding of the judgment in NWK, as was pointed out in Roscon. And then he says, there I stress that simulation is a question of the genuineness of the transaction under consideration. If it is genuine, then it is not simulated. And if it is simulated, then it is a dishonest transaction, whatever the motives of those who concluded the transaction. The true position is that the court examines the transaction as a whole, including all the surrounding circumstances. Well, Peter, I'm sure neither you nor I would ever have denied that you look at all the circumstances in deciding whether something is a sham or not. But then he goes on to say, tax evasion is, of course, impermissible, and therefore, if a transaction is simulated, it may amount to tax evasion. But then he says something which I always think is very important. He says, but there is nothing impermissible about arranging one's affairs so as to minimize one's tax liability. In other words, in tax avoidance. If the authorities regard any particular form of tax avoidance as undesirable, they are free to amend the Act, as occurs annually, to close anything they regard as a loophole. That is what occurred when Section 8C was introduced. This case was about Section 8A, and that's what done. And why I think that's quite interesting is what role does the GAR, the General Anti-Avoidance Rule, play? You know, it's almost saying here that you don't always look at the GAR. You know, that if the taxpayer has successfully avoided tax, then the SARS remedy is not necessarily to use the GAR, but to amend the Act. Anyway, let's not get sidetracked. Time for Judge Lewis to enter the stage once more.
Enter stage left. It's calmer. So the Cecil Oil judgment was handed down November 2018 and was handed down by Judge Carol Lewis. Again, a simulation matter. So the facts here are quite interesting. Cecil Oil importing product from overseas. And they had a company in the Isle of Man, the acronym is SOIL. So SOIL basically imported product and sold it to Cecil Oil in South Africa. And that meant that SOIL's profit was allocated to South Africa under the controlled foreign company rules. So Cecil decided instead of doing that, they were going to get SOIL, the Isle of Man company, to sell the product to a UK company whose acronym is Cecil. And Cecil will then take the product and sell it to Cecil Oil. The effect of this is that SOIL, the Isle of Man company, is no longer selling to a connected resident. It is selling to a connected non-resident. So its profit is no longer allocated and attributed to South Africa under the controlled foreign company rules. And so that was taken to court by SARS using simulation and saying that the introduction of the Cecil entity, this UK entity, was simulated and was not real, and that the true transaction was a sale from SOIL down to Cecil Oil. So Judge Lewis wrote the judgment and again stated that the laws in respect of the test for simulation was not changed by the judgment of the court in NWK, and said that again, confirmed that simulation is a test of the genuineness of the transaction under consideration. The transaction is genuine, it's not simulated, and if it's simulated, then it's a dishonest transaction. So stating the law as it was pre-NWK and saying NWK again didn't change the law. And the majority of the court, in this case, there was a minority dissenting judgment, but the majority of the court found that the transactions between SOIL and Cecil Oil were all genuine transactions. They had legitimate purpose, and that there were good commercial reasons for introducing Cecil into the supply chain. So they found that that these transactions were genuine, they weren't simulated, and therefore, again, SARS lost that case. So, but interesting, and again, I mentioned this under Roshcon, and I think it's important to note that the courts will look at all the circumstances and they look for unusual features in the context of seeing whether a transaction is disguised. And if it's disguised, then it's dishonest and it's simulated. So interesting that, you know, looking at in the Cecil case, again, saying there are good commercial reasons for introducing Cecil. Now, that's again, it's not the test for simulation, but one needs to be a little bit careful about this disguise concept to make sure that a transaction doesn't have an element of disguise. And what we obviously tell clients is if there's an unusual feature of a transaction that doesn't seem to have a commercial rationale, you need to understand why it's there, because that does raise the specter of somebody saying, you're disguising something. You wouldn't normally enter into this transaction. So what are you really doing? So, but again, hold that simulation is a test of honesty. And if the transaction is genuine and is not dishonest, then it's not simulated. And interesting, Trevor, that there've been, since that case, I've noticed SARS sort of steering a little bit away from simulation arguments and focusing more on sort of the GAR provisions. And I think after Roshcon, Bosch, and Cecil Oil all kind of saying much the same thing, I think, SARS have stayed away from sort of arguing that something, because it might lack some commercial purpose, fails the test for simulation.
Yeah, it's interesting that in the Cecil case, I've got an extract from the judgment here. Judge Lewis quotes her own paragraph 55 from NWK, and she says that the judgment in that matter was apparently thought to have changed the law. It did not. It pointed out merely that in order to establish simulation, one could not look only at the terms of the disputed transaction, and it suggested that simulation was to be established not by considering only the terms of the transaction, but also the probabilities in the context in which they were concluded. That was surely always the case. And I mean, an example of where the court did find that there was simulation was the Ladysmith case. Remember, that was a case where It had I think, if I remember correctly, a holding company which let property to a pension fund, which then let it to the subsidiary company. And there was no obligation to erect buildings, which buildings were erected by the lessee. So the lessee got a deduction, but there was no obligation on the part of the, or no right in the part of the lessor. And it was easy for the court to say yes, but that was clearly understood by all of the parties. So yes, I mean, it is something that must be taken seriously. But I think the test is now correct. It's a test for genuineness, and really that's it.
I agree. And it's interesting because there's what some people refer to as the label doctrine or the label principle. And that hasn't been separated out from the simulation stroke substance over form stroke sham doctrine that has been addressed in the cases we discussed, Trevor. But for me, there's something like almost a parallel sort of principle that says, if I sell you something and on the front cover of our sale agreement, I say, I call it a lease agreement. That doesn't make it a lease agreement. You look at what you truly intended, you read the contract, and you say, this is a contract of sale. The fact that you've labeled it lease doesn't mean that it becomes a lease agreement, and it seems trite. But I think that to me is slightly different, because that's sort of a label. By attaching a label to something doesn't mean that is what it is. You still have to look at the legal consequences of the transaction you've entered into. And to me, that's a slightly parallel concept. That's not dishonesty.
No, I agree. And I think it is worth making the point that substance and form can also operate. It's often used to describe a dishonest transaction, fraudum legis, as we've been discussing. But if you take the old case of Achberg, that's where, in consideration for him assigning a lease from the railways and undertaking certain commitments for the future, the remainder of the authorized but unissued shares in the company were issued to someone who was effectively the sole shareholder. Apart from a negligible amount of shares, he was the sole shareholder of the company anyway. And that case is very interesting because the court split, I think, three ways. And some said there was no accrual because he didn't receive anything that he didn't already have, because he effectively was the sole shareholder anyway. And the majority found the opposite. But the interesting thing is that both parties used the substance, or two of the judgments used the concept of substance over form, but to justify the opposite conclusions. And there was no attempt to deceive anybody. They were just, that was a case where Mr. Achberg was in form receiving something, but in substance, some would say he received nothing that he didn't already have, and then the test was used the other way around. But no one would suggest that there was anything dishonest about that. So it can apply in a situation where there's no. That's different to simulation. Simulation implies some intent. Yeah.
Exactly. It's just a different doctrine.
Yeah.
Very interesting, but a happy ending to the story, Trevor.
Yes, far. Indeed, yeah. And even Judge Lewis, who was so misunderstood, is now on the same page.
And Elizabeth, I think, might be the last word on this in Cecil Oil, which I think is fitting.
Yeah. I must say, I once obtained a copy of a speech that she gave at some function to award a prize to a competition for people who wrote the best tax thesis in a particular year. And I happened to get a written copy of her speech. And she said she knows she's controversial because of the NWK and the Founders Hill cases, and she's not going to discuss those this evening. She then proceeded to discuss virtually nothing else. And she made the point that one of the things she was criticized for in NWK was using the term evasion, where I think what she intended was avoidance. Because obviously if it's evasion, then it is simulation. End of story, yeah. And she made the point that she does understand the difference between evasion and avoidance. And Vrachtig, right at the end of her speech, she used the word evasion again, in a sense where it should have been avoidance. Anyway, that's purely anecdotal. And I suppose that's what makes law interesting, that we have different opinions and there's always something to discuss. And, as Eddie Bromberg, who we mentioned earlier, said in his delightful book, Tax Strategy, that there's a Kafkaesque aspect to tax. It somehow seems somehow unreal and a bit arbitrary and all of that, but the consequences thereof can be all too real when you have to write out a check. Peter, I think our time is up, but it's always fun chatting with you. And,
absolutely. Till the next time.
Yeah. Okay. Great to see you again. Right. Bye-bye.